Joe Zarzaur here with Dr. Evan Malone to talk to you about a study that just came out, not a study, it's a perspective, I guess is what it's called, from the New England Journal of Medicine. I think that's your opinion piece, basically. The interesting thing from a legal standpoint is these medical journals, and I think the New England Journal of Medicine is probably the most preeminent, if not one of the top 2 preeminent journals in America, medical journals. They had a piece this last week discussing medical malpractice cases and how there's been a significant reduction over the last 25 years in medical malpractice payouts as a result of medical malpractice lawsuits. The study, which we're going to post a link to at the bottom of this video, talks in some parts about the reasons there's been a reduction. And one of those reasons is, the real reason I want to bring this topic up is that they think that potentially some of the reduction is due to the fact that a lot of hospitals are stepping in and taking responsibility for physician malpractice. And the only way they keep track of these cases is through a physician database that requires the physician, if they're individually sued, if they settle a case or they get a verdict against them, they have to report it to a national database. There is no such requirement for facilities to report such payments. And so some of the reduction in suits over the last 25, or payouts over the last 25 years, may be that there has been more settlements made or verdicts against hospitals and not physicians. The other hypothesis in the study is that perhaps the caps on damages has worked to the doctor's favor in the sense that less lawyers want to get involved in these cases because there's damage caps that are involved. And of course, then they say maybe medicine has also improved, or maybe the hospital's risk management departments have been more aggressive in disposing of these things before they become cases. But I wanted Dr. Malone's opinion because there's an interesting chart in there that shows a significant downturn in the amount of malpractice payouts as a result of malpractice cases, and I just wanted your take on that.
Yeah, and so as Joe mentioned, the hospitals, meaning that they're out front when it comes to a case potentially. Well, all you got to do is drive around wherever you're from and say, that used to be Dr. So-and-so's office. Now it has a hospital logo on the top of it, and it's the same doctor's office. So there's been a trend over the last probably almost 15 years now where hospitals are buying up primary care offices, subspecialty offices. And so it still says that same doctor's name, but on the top of it is, with whatever medical group you're part of. And they are then, they're not being sued, they're being sued as an individual, the doctor, but there's another layer before them, and it's usually the medical group, the hospital system, whatever. And that, I think, is probably what some of these doctors are following in line and saying, okay, yeah, we admit liability, or there's a cap or something like that, and the hospital takes care of the rest, and I'm not in as much of that process, okay? Whereas 20 years ago, it was you're suing a doctor, and the doctor had to take a week out of their clinic time to go meet with their attorney and to go through this whole process. And yeah, I'm going to defend it to the teeth because this is I own this place. I'm the entrepreneur. So I think some of it is shifting from a sense of ownership to an employee type of mentality. So I think that is probably part of it. And then also on the front lines, these acute level care centers are, the hospital-based doctors are all employed by the hospitals, whether it's a intensive care specialist, a hospitalist, or even some of the subspecialists that work primarily in the hospital, where you're a nocturnist or you're a neurology hospitalist or something like that, where yep, this is my office now, and I'm employed by them.
Most importantly, for purposes of potential clients or people with potential medical malpractice cases, there are less and less lawyers that are going to be taking these cases because, as the data shows, there's less and less settlements out there, which means there's less and less law firms that are probably interested in handling these cases. In large part, Florida does have caps on damages in some cases, and those caps do deter many lawyers from handling cases like that. But those are somewhat limited, and the occasion has to be brought about by an admission of fault, many times by the at-fault doctor, which most of the time they don't want to do that, or facility. So if you have questions about a medical malpractice case in Florida, you can find us on the web at zarzaurlaw.com, or you can call us at 855-HIRE-JOE. I would also encourage you, if you're a health practitioner or a physician and you're trying to be convinced to buy a whole bunch of medical malpractice insurance, you might want to look at this journal article and say to your insurance agent, well, I appreciate you scaring me into wanting to buy a bunch of insurance, but hasn't the trend been over the last 25 years that the payouts are less? The data from this particular opinion piece, that's cited in this opinion piece rather, would assist you in potentially negotiating a better insurance rate. So I know that's not why I'm here, to help you negotiate your insurance rate, but I also don't like insurance companies taking advantage of anybody for that matter. So you know how to get in touch with us if you need us. Thank you, Dr. Malone. Check out this article.